be here and share with you the history of the litigation involving SB 54. Again, I hope as you appreciate now that this is a very nuanced issue, and there is litigation at the state level and litigation at the federal level. The litigation at the federal level is commonly referred to as the SB 54 litigation, but that's not accurate or correct. The federal litigation involves a federal preemption challenge to 3 state pieces of legislation: AB 103, which we'll talk about in just a little bit, AB 450, and SB 54. And by the way, there's a handout that summarizes all of this in the back of the room if you'd like to take it with you when you leave. In addition to the federal litigation, there is also state litigation involving a unique creature under California law, and that is the so-called charter city right to regulate regarding local municipal affairs. So let me give you just a little bit of background on that so that you can appreciate that nuanced value. In California, there are 2 kinds of cities. There are general law cities, that is, cities that operate under the umbrella of the general laws of the state of California. And there are charter cities, and charter cities essentially adopt their own constitution. And to the extent that the city charter is not inconsistent with federal law or is not inconsistent with state law, which is to be given universal effect statewide, cities are then free to regulate regarding matters of local municipal affairs. And the courts have defined that over the course of the years, but things that are uniquely local, the charter gets to regulate. So one of the legal issues that has been raised is, does a charter city have to comply with AB 103, AB 450, and SB 54 if they choose to opt out under their local home rule provisions of their charter? There are at least 2 cities in Orange County that have taken that route. One is the city of Los Alamitos, and the other is the city of Huntington Beach. The city of Huntington Beach case recently came on for hearing before the Orange County Superior Court, and the Orange County Superior Court ruled that the city of Huntington Beach, as a charter city, was free to exercise its home rule authority and opt out of complying with those 3 provisions of state law. That will certainly be the subject of a further appeal, and the actual ruling of the trial court has not yet been prepared. The process is, once the trial court renders a ruling, it will order one party to prepare the reasons for the ruling. The other party will get to comment on that. There'll be a hearing, and then the judge will say, "This is my decision," and sign her or his name to it, and from there we go on to appeal. So we have that one issue. Now, what's the significance of that in Glendora? That's not helpful to us in Glendora, because in Glendora we're a general law city, not a charter city, so we are subject to the general laws of the state of California. So that's the state litigation. I don't know what the status of the Los Alamitos litigation is, and haven't heard if there's been a ruling yet or not, but we'll certainly make that information available on the city's website as soon as we know about it, and as soon as we get the written, detailed legal analysis of the Orange County Superior Court judge that ruled in favor of the city of Huntington Beach. We will post that for all of you to read. So now let's turn to the federal litigation. In the federal litigation, the United States sued the state of California over implementation of these 3 sanctuary state kinds of bills. And we'll talk about how the federal district court has ruled on each of these bills one at a time. But essentially, the argument in all 3 cases is that federal law preempts state law to the contrary under the Supremacy Clause of the United States Constitution. And if you've never read it, here it is verbatim. It is Article 6, Section 1, Clause 2 of the United States Constitution, and it reads as follows, quote, "The Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding, close quote. That's referred to as the Supremacy Clause, and there is a vast body of federal court opinions and United States Supreme Court opinions interpreting what those words mean. But in this context, the question is, do the federal laws that have been reviewed with you tonight preempt 3 state of California laws to the contrary? That lawsuit was filed, and then what happened was that the United States government brought what is known as a motion for preliminary injunction, seeking an intermediate ruling from the federal district court barring the state of California and any of its municipalities from enforcing these provisions. Now, why is that important? In terms of federal civil procedure, that is not a final ruling on the merits. That's only an intermediate ruling. And in order for a preliminary injunction to be granted, the district court must conclude that the moving party has a reasonable likelihood of prevailing on the merits of their claim once the merits of their claim come on for hearing and final determination. Ordinarily, rulings, intermediate rulings, or what are known as interlocutory rulings, are not appealable until there is a final judgment, but there are exceptions to that rule, and those exceptions apply to this case. So let's talk about how the federal district court ruled with respect to the motion of the United States seeking the issuance of a preliminary injunction directed to the state of California and its subordinate political bodies with respect to enforcement of each of these 3 pieces of litigation. So let's talk about them one at a time. AB 103. AB 103 adds a law directing the state attorney general to review and report on county, local, and private lockup detention facilities where non-citizens are housed or detained for purposes of immigration proceedings in California. The review includes conditions of confinement, the standard of care being provided detainees, the due process being afforded to individuals housed or detained in such facilities, and the circumstances surrounding their apprehension and transfer to a federal facility. Further, AB 103 requires administrators of facilities to grant access to the Office of the California Attorney General to effect these reviews. So here's how the Federal District Court ruled on that issue. The District Court concluded that federal immigration law does not prevent any state oversight of detention facilities operating within state borders, despite the broad grant of federal authority to regulate immigration. The District Court ruled that AB 103 does not give California a role in determining whether an immigrant should be detained or removed from the country. Instead, the directive contemplates increased transparency on the conditions and circumstances of individual detentions. AB 103, the court concluded, does not impose any substantial requirements on detention facilities, facility operators, except to the extent to provide access to the Office of the California Attorney General to undertake this review. The District Court denied the injunction, which would have prevented California from enforcing AB 103, and then the state of California brought a motion to dismiss that claim by the federal government, and the District Court granted that motion and dismissed that claim. So as we sit here tonight, the current state of the law in the federal court system in California is that AB 103 is fully constitutional and enforceable among the general law cities and state jurisdictions within the state of California. AB 450. AB 450 imposes requirements on public and private employers with respect to worksite immigration enforcement activities. It specifically prohibits employers from providing voluntary consent to an immigration enforcement agent to enter non-public areas of a place of work to access, review, or obtain employer-employee information. Employers must provide notice of any impending I-9 inspection within 72 hours of receipt of that notice. Employers are prohibited from re-verifying the employment eligibility of current employees when not specifically required by federal law. So the district court looked at AB 450 and reached the following conclusions. The district court held that several provisions of AB 450 targeted federal immigration enforcement. The provisions related to the imposition of monetary penalties on employers that cooperate with federal immigration enforcement via consent to non-public areas and access to employment records were determined to be in direct conflict with federal laws regulating employment and legal status. The district court found that the prohibition on re-verification by employers of the immigration status of employees constituted an obstacle to federal enforcement, again because of the extensive federal regulation of immigration in the workplace. The district court granted the preliminary injunction preventing enforcement of these elements of AB 450, and these claims were not dismissed and will proceed forward to a trial on the merits. However, the federal district court rejected the challenge to that portion of AB 450 that required 72-hour notice to employees of an I-9 immigration inspection. The district court rejected the argument that providing 72-hour advance notification to employees would hamper immigration enforcement efforts. The court rejected the argument of the United States that undocumented individuals would evade federal enforcement as a result of such notice requirements. The district court therefore denied the issuance of a preliminary injunction to prohibit the enforcement of the required 72-hour advance notice. Lastly, the court turns its attention to SB 54, about which you have had a remarkably clear and detailed explanation. The district court rejected the arguments of the United States with respect to SB 54, which prohibited information sharing between federal immigration enforcement and state immigration enforcement concerning in-custody immigrants. The court found that SB 54 specifically permits information sharing in specifically described circumstances and does not prohibit the sharing of information that federal law specifically requires. Information like addresses and release dates which are not specifically covered by federal law, California was free to regulate on and to prohibit the release of such information. The district court summed up its opinion on SB 54 as follows. Quote, refusing to help the federal government is not the same as impeding. The federal district court then issued an injunction, denied the issuance of a preliminary injunction enjoining the enforcement of SB 54 and dismissed the federal claim in that context. On August 7th, 2018, the United States government filed an appeal of the rulings of the district court with the Ninth Circuit Federal Court of Appeals in San Francisco, California. The opening brief of the United States was filed with the Ninth Circuit on September 19th, 2018. If you go to the Ninth Circuit's website and look up the federal sanctuary litigation, you'll be able to see that brief and read it for yourself and judge its merits or lack thereof. As of tonight's town hall meeting, the state of California still has until November 5, 2018 to file its opening brief. Once the federal court opening brief is filed and the state court opening brief is filed, because the federal government is the appealing party and carries the burden of proof, the federal government will be afforded a right to provide a reply brief. As of tonight's town hall meeting, there have been 30 amicus briefs filed on both sides of the issue, including 15 amicus briefs by 15 of the states throughout the United States. So all sides of the litigation are adequately represented by an extensive body of amicus briefs. An amicus brief is a brief filed by someone who is not a party to the dispute, but who has positions, facts, and other information that the court may find helpful in making its decision. I would not expect that there will be a ruling out of the Ninth Circuit or even oral argument out of the Ninth Circuit much before early next year. And this case certainly will make its way to the United States Supreme Court.
Yes.
So that is the status of the so-called SB 54 litigation, and that ends my portion of the presentation. I'll now turn it over to the Los Angeles County Sheriff's Department.